Good morning to all of you. అందరికీ శుభోదయం. వెల్కమ్ టు లీగల్ మ్యాటర్స్ బై సాయిబాబు సుక్క. This video relates to spousal communications, which are privileged communications previously under section 122 of the Indian Evidence Act. The important point is whether husband can record the telephonic conversation of his wife without her knowledge and produce in the court as evidence. Whether it is acceptable or not, whether it is barred by section 122 of the Evidence Act or not. That is what we are going to discuss in this court. The matter has come to the level of Supreme Court. Honorable two judges, Justice Madam B.V. Nagaratna and Satish Chandra Sharma, in the case of Vibhor Garg, male husband, Vibhor Garg versus Neha, SLP number 21,195 by 2021, decided on 14/7/2025. That means, of course, for us today, for you it is yesterday, wherein it was held that secretly recording wife's conversation is admissible in evidence. It is no bar under section 122 of the Evidence Act, and it is actually admissible under section 14 of the Family Courts Act 1989. This is the rule. So when once Supreme Court decided the case, yes, you have to follow. Friends, for the second year students, I want to reiterate that in my law of torts classes, I told you the spousal communications. Actually, it starts with the relationship between a client and an advocate. If a client comes and says that I have murdered so and so, please help me, then as a lawyer, are you duty bound to surrender him to the court or you assist him? Of course, you all of you are very smart. You said that yes, we have to help him. We need not send him to the court. That means the communication between the lawyer and so-called client is privileged. Likewise, in the Indian Penal Code, wife is supposed to be man includes woman, wife includes husband. Jocularly, will be telling. If your wife makes a purchase in a restaurant or in a mall, you have to pay the bill. And coming to today's topic, section 122 is very, very important. In the previous case, law of torts, I forgot it. In the case of MC Verghese or something, MC Verghese versus T.J. Pannan, 1967 case, I told you that in the initial stage, up to the High Court level, they said that the communication between wife and husband is privileged. But Supreme Court said, when it comes to the matter where the husband abuses the father-in-law, it is the duty of the daughter to inform him. Of course, after getting information, whatever action he has taken, yes, allowed. So it does not infringe upon Article 21 of the Constitution of India. It does not infringe the right to privacy. Likewise, in the case of medical negligence, I told you, Dr. Tokuga case, where he was infected with the so-called HIV positive, and the Apollo Hospital told the would-be bride that he is affected with so-and-so, and he filed a case against Apollo Hospital. How can you inform my health status to the other party? And Supreme Court said, had the Apollo Hospital authorities not told, her life would have been jeopardized. Is it not? So, a very fundamental right, it has got its own limitations. Now coming to this case, Vibhor Garg versus Neha. Their marriage was solemnized on 20/2/2009. As a result of their happy marriage life, a baby girl was born In the year 2011, of course, differences cropped up with them, marital discord arose, and in the year 2017, he filed a divorce petition under Section 13 of the Hindu Marriage Act in the family court at Batinda on 7/7/2017. Marriage took place in the year 2009. మొత్తం 8 ఏళ్ళు కూడా కాపురం జరగల. Right. He filed a petition for divorce. And దీనిలో he filed an affidavit that he may be permitted to file the telephonic conversation, that means which was stored in the mobile chip or memory card, something like that. The wife objected, but ultimately family court allowed the same. And got into evidence. Then immediately wife filed a revision before the High Court of Punjab and Haryana, which concurred with her and said that the communication between wife and husband are privileged. Therefore, husband is not allowed to produce the telephonic recorded conversation against the wife. ఎడవడం సామాన్యం కాదు. వైఫ్కి తెలియకుండా వైఫ్ కన్వర్సేషన్ అంతా రికార్డ్ చేశాడు. అఫ్ కోర్స్ విత్ ద అడ్వెంట్ ఆఫ్ టెక్నాలజీ, కమ్యూనికేషన్ స్కిల్స్ ఇప్పుడంతా అది కామన్ అయిపోయింది. ఒకప్పుడు మాకైతే ఆశ్చర్యంగా ఉంటుంది కదా, మీకు ఇది కామన్. హైకోర్ట్ సెడ్ నో, ఇట్ కెనాట్ బి టేకెన్ టు ఎవిడెన్స్ బికాస్ ద ప్రివిలేజ్డ్ కమ్యూనికేషన్స్. దెన్ నౌ ద మ్యాటర్ హ్యాస్ కమ్ టు ద సుప్రీం కోర్ట్. దిస్ మ్యాన్ Vibhor Garg, he has come to the Supreme Court allowed the same. Family Court under Section 14 of the Evidence Act, 14 of the Family Courts Act, they can take up evidence because others, just like other witnesses, will not be there in marital disputes. Section 14 of the Family Court Act allows all types of evidence. In matters of cruelty, the parties are bound to recreate the issues and the events which happened in the home, in the bedroom, which is away from the public eye. No witnesses will be there for such events. In the present age of technology and computers or the modern electronic devices, evidence can be brought. Of course, as a matter of caution, Supreme Court said, high courts should circumspect the reliance upon such evidence charge. ఎందుకంటే దీంట్లో మార్ఫింగ్ చేసి డూప్ చేసే బ్యాచ్ కూడా ఉంటారు. సో సెక్షన్ 122 డస్ నాట్ క్రియేట్ ఎనీ బార్. అక్కడ కూడా సుప్రీంకోర్టు వర్గీస్ కేసు, టీజే పన్నన్ కేసులో కూడా క్లియర్గా చెప్పింది. సో యాజ్ పర్ ఆర్టికల్ 21, రైట్ టు ప్రైవసీ ఈజ్ నాట్ వైలేటెడ్. ఆఫ్ కోర్స్, some people here also, the argument on behalf of the wife is that if Honorable Court permits such type of evidence, it would destroy the family harmony, the marital harmony. Divorces will become more. But Supreme Court said, law should be law. You can't depend on the sentiments of the people. So therefore, the evidence can be taken. And defense in this case, they have produced our Honorable High Court of AP judgment. Supreme Court negated the same. So please note down the AP High Court judgment. That is Srimati Rayala M. Bhuvaneshwari versus Napa Panindar Rayala, 2007. Here, the husband tapped the mobile phone of the wife and recorded her and retrieved her statements, which was not allowed by High Court of AP. Right? But Supreme Court said no. The conversation will act as an aid to the court to come to a definite conclusion. So friends, remember, ఇక్కడ నుంచి జాగ్రత్త. వైఫ్ యొక్క కన్వర్సేషన్ రికార్డ్ చేసి హస్బెండ్ ప్రొడ్యూస్ చేస్తే ఇట్ విల్ బి టేకెన్ యాజ్ ఎవిడెన్స్. Right? Very important case law. Read it and enrich your legal knowledge. I am stopping here. Thank you very much.